Hello, my name is Justin. I am a reference librarian at the University of Texas School of Law, and I recently ran across this video from a company called Msty.AI. It is a video where someone from the company is demonstrating an integration of what he calls a shadow persona. So this is an additional tool you can use to verify the output of a baseline LLM. And the thing about the shadow persona is that it purports to use this Courtlistener API in order to double check the citations that the baseline LLM, the underlying LLM, gave you. So this is the video from Msty Studio, Msty.AI Studio, I guess. I'll put the link in the description. I don't know if their video is going to stay up. But basically, this guy walks you through how to use a Courtlistener API. So he says, sign up for an account, get an API key, and then put it into this new tool that they have called a shadow persona, which is supposed to verify the output of a baseline LLM. So after you do all of this, looks very impressive, looks like it's pulling information from Courtlistener. He eventually gets to a point where he has a few case citations. So here the underlying LLM says, here are the 4 cases consolidated into Brown v. Board of Education, and then it has 4 listed cases. And then the innovation here supposedly is the use of the shadow persona. So although the box in the left-hand side is the output from the LLM, the baseline LLM, the shadow persona is able to verify the citations that the underlying LLM is giving. So in this case, you can see here that it says this particular citation is accurate, this citation is accurate. If we scroll back a little bit here, it says this citation is partially accurate and this citation is accurate. So overall, what looks like a pretty cool integration. I wanted to pause here and let's first look at these citations. So the first one is Brown v. Board of Education of Topeka specifically, and it says that the reporter number here is 347 US 483. So what we can actually do is that we can go to Courtlistener itself and search for that reporter number. So when I have a reporter number and I'm on Courtlistener, what I like to do is go to advanced search, because I can just pop it into that citation box and hit search. And in this case, we can see that Brown v. Board of Education is indeed a 1954 case at 347 US 483. And then we have some other parallel citations as well. What about this next case, Briggs v. Elliott? So Briggs v. Elliott, the underlying LLM, says this is 342 F2D 229 from the 4th Circuit in 1965. And the shadow persona says that this citation is partially accurate. Okay, let's see if we can find this case. Let's pull that number. So 342 F2D 229. And in this case, we get 4 results. And the one that actually hits on this particular page of this particular volume of the Federal Reporter 2nd edition is this case called Shirley Bivens v. Board of Public Education and Orphanage for Bibb County, Georgia. And it's also a 5th Circuit case instead of a 4th Circuit case. And this really confused me because the shadow persona that this guy is trying to sell you says that this citation is partially accurate. It says, while the case did involve desegregation and was heard by the 4th Circuit, it wasn't heard by the 4th Circuit. The citation provided refers to a Supreme Court case reversal of Brown 1 rather than appeal related to this case. So I'm not exactly sure what this partially accurate determination means, because it seems like if the case is not being described for the correct proposition, then I would assume that that's entirely inaccurate as opposed to partially accurate. Furthermore, the name of this case, Briggs v. Elliott, does not align with the citator number or the information of the parenthetical given here. And that got me thinking, is Briggs v. Elliott a real case? So you can go to Google, and if you search Briggs v. Elliott, you actually find out that it is a real case. And one site that I found that I thought was very useful and instructive is this one by the National Park Service. So it actually has a page for the cases which got bundled together into the Brown v. Board of Education decision, which, remember, is the topic of legal research that the underlying LLM is being asked to do here. But in this case, also notice that it says, here are the 4 cases consolidated into Brown v. Board of Education, and from the National Park Service site, we can see that there were 5, right? Of which one is Briggs v. Elliott. Wonderful. Okay, Briggs v. Elliott is a real case. However, the National Park site doesn't have a citator number for this Briggs v. Elliott case. So I saw that another result here was Justicia, or you can go to Wikipedia. In either case, we see that Briggs v. Elliott, and here we can actually read the case itself, right? We can go and we can read the opinion of the case to make sure that it stands for the legal proposition that we would cite it for, is at a different citator number and from a different year and from a different court than the one that is listed and verified as partially accurate by this shadow persona, by this guy's AI tool. Okay, let's move on to the next one. So Davis v. County Board of Education of Prince Edward County, supposedly at 103 F Sup 337 in a district court in Virginia, 1951. So we can grab that citator number and go back to our Courtlistener. Wonderful website, by the way, Courtlistener. They do so much in terms of access to justice and making case material available to the public. And we can see here that indeed at this reporter number, there is a case called Davis v. County School Board, right? Davis v. County School Board of Prince Edward County, Virginia, and it is from a district court in Virginia. However, if we look at this, we can see that it was decided in 1952. Why does the underlying LLM first say that this is from 1951, and the shadow persona also says that the citation for Davis here is deemed accurate? It's not. The citation has inaccurate information in it. Okay, let's move on to this last one, Gebhardt v. Belton. So 173 A2D 903 from a Delaware Chancery Court in 1963. So again, we will grab the citator number, and from a reputable source, in this case Courtlistener, we can plug that in, and we can see that there actually isn't a case by that number at all here. So what I did, because I am here in a law library, is I walked over to our shelf where we have the Atlantic Reporter, 2nd edition, and pulled out volume 173. You could also do this on Westlaw. Maybe you could do it on Google Scholar. Many ways to skin a cat. But what I can do is I can go to this particular volume and I can look at page 903. And in this case, the reason why it does not cite me to a case that begins on page 903 is that 903 is smack at the end. It's this last page of a completely different case. It is a case called State of Connecticut v. Roland La Riviere, and it starts on page 900. So you can see here that the case starts on page 900 and it ends on page 903, right over there, page 903. So this case name, Gebhardt v. Belton, looked familiar to me, and it was from this 5 cases webpage from the National Park Service. So if we scroll down, we can see that there is Belton v. Gebhardt here. Sometimes the names of the parties, different levels of appeals get flipped around. That's fine. So this is indeed a real case. Let's see if we can find the actual reporter number for this particular case. Go back to Google, type in Gebhardt v. Belton, and again, you can find it on Wikipedia. You can find it on Justicia. In this case, we have 91A2D 137. And we can verify this if we want to Justicia is also a great site, but here on Courtlistener, we can see that we do indeed get Gebhardt v. Belton at this specific citation, so this volume of this publication on this page. What I want to do now is step back a little bit and talk about the results that this LLM got and that were supposedly verified by this other LLM, the shadow persona, which is supposed to be, some kind of agent, some kind of additional tool that can be used to verify the output of an LLM. The proposition here, if you read the text that was generated, is that there were 4 cases that all got consolidated into this decision, Brown v. Board of Education. Therefore, we would expect that all of the cases that got combined into a subsequent case existed at that time, meaning that they were decided before the case which is supposed to consolidate them. And if you look at this list of cases, chronologically, it really struggles with that basic concept. So Brown v. Board of Education, 1954. And then it gives you Briggs v. Elliott, 1965. And it also gives you Gebhardt v. Belton, and it says 1963. We know now that those dates and those citator numbers are false. Real case names, but not at that citator number, and not, in the case of Briggs v. Elliott, not from that court, and definitely not at that date. Right, so we know that despite what the shadow persona here says about things being accurate to partially accurate, they're very inaccurate. They're wildly inaccurate. But would you not expect that a case which got consolidated into Brown v. Board of Education to have a date earlier than Brown v. Board of Education? Is time not linear? Is my question here, right? Like, Gebhardt v. Belton, 1963, just time travels to a decade before in order to get rolled up into the consolidated Brown v. Board decision. That simply does not make sense on a logical level, regardless of, complexity of the court system. And I have a lot of sympathy for people who struggle with legal citations because I've spent a lot of my life struggling with legal citations. It is a complicated, a very abstruse knowledge set and skill set. So I have a lot of sympathy generally for people who are confused and are maybe overwhelmed by legal citation form, and organization of, things like case reporters in our very complex legal system. That's fine. That's not what's happening here. What's happening here is like a struggle with the concept of time, the linearity of time. So my question at this point is less about why didn't the tool work, because why didn't the tool work is fundamentally a technical question. We could look at what the API did. We could look at, maybe do some traffic analysis. We could look at the actual inner workings, whatever, behind the hood analytics that Msty.AI Studio happens to have and could scrutinize or provide. And my question is more about, why did this get posted? Because I would imagine that if you wanted to put out a video, some kind of marketing material, some kind of client demo about your tool being able to do accurate legal research, one of your priorities, in fact, a very high priority, would be to show that your tool could do accurate legal research. Stated differently, you'd want to ensure the accuracy of the legal research being done by your tool in your demo. And that simply was not the case, right? And we're not talking about an obscure kind of like, oh, it's really unrepresented in the training material. We're not talking about something that's super off the beaten path in this instance. We're talking about Brown v. Board of Education, right? In the United States legal history, very few cases have had the kind of impact, the kind of scholarship, the kind of analysis, the kind of writing, the kind of mere presence, right, that Brown v. Board and its constituent cases have had. Yet in this case, this was the outcome. We could try to answer that question about why this got posted in any number of ways. We could chalk it up to, any kind of balance between incompetence or malice, right? Hanlon's law notwithstanding. We could chalk it up to, maybe this guy just doesn't know. Maybe he doesn't understand the kind of technical rigor that doing legal research often entails. So if I were to try to answer this question of why this got posted, I think that it comes down to the fact that the appearance of doing accurate legal research is more important than actually doing accurate legal research to this company at this point in time. And this is something that I feel like I'm seeing more and more as legal AI utilities, software as a service, whatever you want to label it, is just inundating the legal tech market. Is that a lot of times people are more concerned that something looks like it's doing the correct job as opposed to its actual ability to do that job. So if you're someone who's evaluating a tool like this, you get to decide whether or not those priorities align with your own, whether or not the appearance of being able to do legal research is more important than doing the legal research itself. And you get to make those decisions and spend your money accordingly.